30. We are going to jump right in today. This is kind of a dry lecture, if I'm being honest. But it is absolutely essential, so it's important that we go over it. And I have gone through and just made some notes of key points that I think will be good to remember for your quiz, and just to simplify the information down a little bit. I feel like there's quite a bit of information here, and it can be a little overwhelming. So yeah, bear with me. We'll get through it. It'll make more sense when we get towards the end of it. So let's go ahead and jump right in. I have kind of looked over here at the learning objectives, but I'm going to just pass through them. I feel like those are things that you can scroll through if you'd like. So we're going to go ahead and start with the Code of Ethics. So the overview of this entire chapter, Chapter 5, the ethical and legal implications of practice. While this isn't necessarily our specialty in respiratory care, there has to be an ethical and legal aspect to respiratory care, or it would not be able to be applied to such a systemic healthcare field, So there has to be rules. There has to be the people have to be governed within this set of ethical and legal implications. So that's kind of the overview, I feel like, the main gist of this chapter. So what is a code of ethics? It is an essential part of any profession claiming to be self-regulating. So respiratory therapy definitely falls under this self-regulating. So this code of ethics is a code that respiratory therapists uphold themselves as they choose to treat their patients. And it's like the bro code. Like, these are the things you do, and these are the things that you don't do, And there's this, not invisible, but because it's documented, code of ethics, but there's this set of rules and ways that you conduct your practice as you're taking care of patients. The AARC has a statement of ethics and professional conduct. General principles developed to help ensure that health needs of the public be provided in a safe, effective, and caring manner. Goes through, and there are quite a few posts, or quite a few little bullets in here. This is a little bit tricky to read. Maybe I can blow it up a little bit here. Go ahead and go through and read those. I don't want to, this is super wordy, so I'm not going to read every single post in here. But, for example, respect and protect the legal and personal rights of patients that they treat. That obviously it's almost common sense and common courtesy that you would give somebody. Divulge no confidential information regarding any patient or family unless disclosure is required for the responsible performance of duty or required by law. Provide care without discrimination, promote disease prevention, refuse to participate in illegal or unethical acts, follow sound scientific procedures and ethical principles, comply with state or federal laws that govern and relate to their practice, avoid any form of conduct that creates a conflict of interest, promote healthcare delivery, and encourage and promote appropriate stewardship of resources. So just a few, like I said, it's very common courtesy. Just treat other people kindly. Use your resources well. Use your brain. Do things to provide the best care that are science-based for your patients. Yada, yada, yada. Ethical theories and principles. Ethical theories and principles provide a foundation for all ethical behavior. These ethical theories and principles can be all grouped within these areas down here at the bottom of the screen. Most ethicists agree that the following are primary guiding principles in ethical decision making. And so we'll go through each and every one of these. Autonomy, veracity, non-malfeasance, beneficence, confidentiality, justice, and role fidelity. Autonomy. Let's make sure that you've got your notes out. Autonomy is a pretty important one. There may or may not be a quiz test or quiz question on it, so make sure you take good notes. Autonomy acknowledges the personal liberty of patients and their right to decide their own course of treatment and follow through with a plan on which they freely agree. The basis for informed consent, and under this principle, any use of deceit to get the patient to reverse the decision to refuse treatment is considered unethical. Autonomy essentially means that the patient has the right to make informed decisions for their own care. Like, they have that right to know what's before them and to be able to make that choice. So that's crucial in being able to give people dignity when you're treating them, to give them confidence, to give them, what's the word that I'm looking for? Just the sense of still being able to have a little bit of control over your body while you're sick. I think it's critical in healthcare. So let's go over a couple questions. What does the principle of autonomy allow patients to do? A, have an attending physician decide their course of treatment. B, have the patient's family decide their course of treatment. C, allow the patient to decide their own course of treatment. Or D, force the patient to have their family member sign a consent form for their treatment. Those all sound pretty rough when thinking. I like to look at these and think of myself in that situation, and I am a pretty independent person. So going through and seeing these people that we're treating in these positions where a lot of the time they can't make their own decisions, like people who are on a ventilator, for example, the next of kin makes their medical decisions. And if they're not on a ventilator and they have the ability to talk, but they are still critical and don't have a lot of control of anything else around them, they do have control over what happens to their body, and they do get to choose. And it is important that it be their decision, not influenced by their family, not influenced by their doctor, and not influenced by their spouse. I know that sounds kind of counterintuitive, but sometimes they're not all on the same page, and they're not all doing things for the same reasons. So it's important that we give patients the autonomy to be able to make the decisions for their own bodies and for their own health care, just to keep them the ones in charge of their bodies. There have been a couple times that I have seen where a patient had disclosed that they didn't want to be intubated. It was kind of palliative care toward the end of their life, and they didn't want any more intubations. They didn't want to have compressions. They didn't want any resuscitative efforts, basically. And that can be a hard thing for families to hear, you know. I can imagine that is really difficult when you love somebody so much that you want them to be around, you want someone to do everything in their power to save them, but you have to take a step back from that situation and think to yourself, like, if that were me and I'm sick and hurting, like, you have to respect the decision of the person in that body. So sometimes they do conflict, and that's a hard situation, but we treat patients, we don't treat families, and we are advocates for our patient, and we work to give them the autonomy that they deserve as we treat them. So let's choose our answer here. The answer is C. We choose to allow the patient to decide their own course of treatment. I think the rest of them are pretty red flag-ish that they're not correct. So, moving forward, veracity. I think that's how you say it, veracity. This is a principle that binds healthcare provider and patient to tell the truth. Both parties are best served in an environment of trust and mutual sharing of all information. So this means that every bit of information that we collect from our assessments, from our testing, from, you know, whatever it is that whatever procedures that we are collecting, that we are doing, and evidence that we are collecting, we disclose that to the patient, and we don't hide that from them. It's their body. They deserve to have all of the information. Moving on to non-malfeasance. There we go. This is a principle that obligates healthcare providers to avoid harming a patient and to actively prevent harm when possible. Problems occur when treatment has serious side effects or double effect. Many helping actions have good and bad problems that come from whatever it is that we're trying to do. If the first intent is good, the harmful effect is viewed as an unintended result. So this one can be kind of tricky because, you know, in healthcare, we are striving to always avoid harming our patient, and doing the best we can to treat them and move them forward in an upward trend. We want them to get better. We want them to go home. And sometimes doing procedures and what we think is best for the patient isn't always the right course of action, I guess is what I'm trying to say. You hear, doctors that take the oath in medical school, the Hippocratic oath, that they will do no harm to their patients. And sometimes that looks like no more, I think of cancer when I think of these cases, because there's so much so many case studies, so much trial and error, and sometimes you're hurting somebody and they don't live, and you wonder, how ethical is this? How ethical is it that we're trying and we hurt this person, and in the end we're advancing and we're moving forward, but that's kind of hard for that one singular patient who helped to move the cure a little closer, I guess, but who didn't survive the course of treatment. So, like I said, these can be really tricky because there's two sides of the sword on almost all of them. So, we do our best to do no harm, to not do more harm than possible. Sometimes it feels like we're harming them because they're so uncomfortable, but truly what we're doing is trying to get them better. Or, I had a case a couple weeks ago where I was at primaries and this poor little 8-year-old boy had to have a lumbar puncture, and we all had to hold him down while they were trying to access his spinal column, and it was horrendous. It was so terrifying for him and traumatizing for everybody else in the room because he's just screaming, and you feel terrible because they don't understand, and in that moment, I'm sure he thought we were harming him, and there's no way that this could be a normal thing to be taking place in a hospital. But truly, we were trying to do what was best for him and to cure him and get him better and get him healthy. But yeah, you can see both sides on all of these ethical principles. They can be really tricky. Beneficence, like I said, raises the do no harm requirement to the higher level, requires healthcare workers to contribute to health and well-being of their patients. Dilemmas in this domain have led to development of advanced directives. So an advanced directive, for those that don't know, are things like a DNR, DNI. They're a piece of paper that usually is notarized and placed in somebody's will, or not notarized, just kind of, sometimes they're just written down on a piece of paper, but something from the patient that says how they would want their body and their health to be treated if they couldn't speak for themselves. So sometimes you have critically ill or terminally ill patients who don't want to be intubated anymore if they get sick, and don't want to be resuscitated if they are coding. And so you have to honor the wishes of those patients because their advanced directives have spoken for them, even though in that moment they can't speak for themselves. And this can be kind of tricky too, because you have advanced directives, but sometimes you have families that disagree with advanced directives, and then it gets really, really, really nitty-gritty. So I'm not even going to go into that because I don't feel remotely qualified to be able to explain about that. But I've seen that before too, where an advanced directive was different than what a family was wanting to do, and they had to figure out what to do in that situation. So both sides of the sword, we do the best we can. That's really what it all boils down to, is that we do the best we can. Confidentiality requires healthcare workers to respect patients' right to privacy. The Hippocratic Oath, respect the secrets which are confided even after the patient has died. In certain situations, healthcare workers are permitted to share patients' medical history with others. The risk of inadvertent disclosure of patients' protected health information has increased exponentially with the advent of social networking sites. This is a huge one, especially, like it said, with social networking and with everybody so big into taking pictures and documenting everything that takes place in their lives. This can be really hard because maybe you have this really wonderful patient that you love so much and you want to take a picture with them, and then you take a picture and you post it on your social media account, but that patient's family didn't want anybody to know that they were in the hospital, and now they're all over social media and it shows that they're in the hospital, and you just violated their right to privacy to be there in that hospital. Maybe they didn't want anybody to know they were there, There are so many different ways. I recently had an experience at a hospital that the patient was taking pictures of the staff and posting them on social media, and that too is a violation of healthcare workers' right to have confidentiality in their work as well. So, two sides of the sword. It can go both ways. But it is absolutely critical in the healthcare field that when you are treating your patient, that you don't disclose information about their health, about their medical record, about their procedures, about their course of treatment, about it's very important that we keep those things private for those patients, especially in this day and age with social networking and people being able to find information basically anywhere. So another question here: which poses the newest, most contemporary risk of violating the patient's right to confidentiality? A, staff meetings. B, healthcare workers' use of social networking sites. C, meeting with patient family members. Or D, medical conferences. So this one can be kind of tricky because I feel like all of these can pose a certain risk. You have staff meetings where you're talking about everybody, but those are pretty crucial. I guess I'm thinking about like patient care team meetings versus staff meetings. But the newest, most contemporary risk of violating the patient's right to confidentiality is B, the healthcare workers' use of social networking sites. So like we talked about, you just wanted to take a picture with your cute patient that you love, and lo and behold, then you're in a lawsuit because you violated that patient's right to confidentiality. Or there was a big thing going around where a nurse took a picture of the ER after they'd had a trauma come in, and this person, there was blood all over the floor, there was materials, there was everything from this code that they were trying to use to take care of this patient, and this room was trashed. And she took a picture just of the room, and I'm pretty sure the name was on the board in the background, and so that violated the patient's right to confidentiality, and then, it can spiral out of control really quickly. You can never be too safe when it comes to your patient's confidentiality. Moving forward, another ethical principle, justice. This involves the fair distribution of care. Balance must be found between healthcare expenses and revenue available to pay for them. Rationing of healthcare services calls for distributive justice. Compensatory justice calls for recovery of damages incurred from medical malpractice. Less than 2% of healthcare costs are related to medical malpractice or negligence lawsuits. Costs represent little, if any, impact on cost of healthcare. So I found this one pretty interesting because when I think of justice, I think of, breaking the law or solving a murder case or whatnot. But justice involves both sides of the coin because you have a patient who you want. You have the patient side, and patients deserve to be treated, right? Regardless of race, color, age, sexual orientation, whatever. Everybody deserves to have the right to be treated. And then on the other side of the coin, you have the healthcare system. These healthcare workers in the hospital are showing up to treat these patients, but what if the patient can't pay? Where we served justice for a patient by treating them even though they can't pay, but justice still needs to be served on this other side of the coin, on the healthcare side, because those healthcare workers need to be paid, the hospital needs to be paid. There's got to be some sort of leeway or give on that side of the coin as well. So tricky. Here we are with ethics again. I mean, we could talk all day about ethical principles. It gets pretty nitty-gritty. Role duty. Practitioners have the duty to understand limits of role and to practice with fidelity. Respiratory therapists must not perform duties outside of the defined role. This is pretty crucial too, because as a respiratory therapist, you have this defined scope of practice where you are certified and allowed to perform certain skills and assessments and whatnot. And if you're acting outside of that scope of practice, you're liable for whatever happens, but you're also liable because I would say that you're working almost illegally, because your respiratory therapy degree, your respiratory therapist certification, registration, whatever you want to call it, allows you to do certain things. And if you're working outside of those things, you're doing something without that certification, which could get you into a lot of trouble. So remembering and working within your scope of practice is absolutely critical to making sure that you are acting in an ethical way. Ways of making ethical decisions: formalism, consequentialism, virtue ethics, and intuitionism. Formalism is the viewpoint relies on rules and principles. This is a duty-oriented reasoning. Consequentialism is based on assessment of consequences. Virtue ethics, what would a virtuous person do in a similar circumstance? And intuitionism holds there are certain self-evident truths, usually based on moral maxims. Treat others fairly, for example. Let's see, moving forward. There, like we talked about before on this other side, formalism, consequentialism, virtue ethics, and intuitionism. Multiple mixed approaches for making moral decisions, for reasoning. Those four categories try to capitalize on strengths of formalism and consequentialism. The rule utilitarianism approach. This is a rule which is concerned with what would promote the greatest good. Disadvantage here, though, is that there is a lot of variability between caregivers. What does that greatest good look like? I don't think there's a right or wrong answer to that. So that gives a huge, like it says, risk of inconsistent ethical decision making. There's no right or wrong way to do it if you're just looking at it based on what one or two or three people think is the greatest good. I'm using my hands as quote greatest good right now, but you can't see, so I thought I'd tell you. Let's see. Ethical decision-making model. This is a really good little diagram here. It just goes through a bunch of questions that you can ask yourself if you're trying to make an ethical decision. So 1, identify the problem or the issue. 2, identify the individuals involved. 3, identify the ethical principle or principles that apply. 4, identify who should make the decision. 5, identify the role of the practitioner. 6, consider the alternatives, long-term and short-term consequences. 7, make the decision, including the decision not to act, because not doing anything is still a choice, right? And then follow the decision to observe its consequences. This is really breaking it down here. Basic decision-making on what to do for our patients. So then we have these systems of law, right? We have these what is ethical reasoning? What drives our morals? How do we take the best care of our patients? What's the moral way to take care of our patients, right? So we have that way of thinking, and then we have the law on our side that stands behind those that moral and ethical way of thinking to back us up and to support us. So we've got these two systems of law, public law and civil law. Public law is broken down into two major divisions. It's the criminal law and administrative law. Criminal law deals with acts against welfare and safety of the public, and administrative law consists of regulations set by government agencies. Civil law protects citizens from others who might seek to take unfair advantage. So this is a super wordy way of explaining it. I feel like the best way that I could think about it was criminal law is like Judge Judy. No, it's not Judge Judy. Criminal law is like Law and Order or a murder show. That is a criminal law setting. Administrative law would be like what a president would go through, or somebody acting in the military would go through. And then civil law would be where people would be more like Judge Judy, where they're coming in, they're mad at this person, they did this, and they're trying to solve it civilly. And have somebody basically mediate and solve the problem. Nobody gets a record, nobody gets a ticket, nobody has to pay a fine to the state. Sometimes they have to pay back, or what I'm trying to say is that the state isn't necessarily involved like they are in civil law and administrative law. So, what system of law consists of the regulations set by government agencies? A, civil law, B, criminal law, C, administrative law, or D, ethical law? Administrative law is the correct answer. They are the agency that consists of regulations set by government agencies. So then we have tort law. Tort law is civil wrong committed. Tort means that a civil wrong was committed against an individual or property for which court provides remedy in a form of action or damage. Intentional tort involves willful act violating another's interest, and negligent tort is failure to perform one's duties competently. I think we can all kind of think of examples of things that have happened in our lives where they would fall under these categories. I was thinking the other day while I was looking through this about one time at Christmas when we were coming home from our family Christmas party. It was Christmas Eve, I remember, and we had received all of our gifts from my in-laws for Christmas. They celebrated Christmas on Christmas Eve, so all of our Christmas was in the back of our car. We were just married, super poor kids, and we left all of those presents in our trunk and went to sleep. And somebody in the middle of the night on Christmas Eve, like, you really have to be desperate, I feel like, to break into our car and steal all of our Christmas presents. I'm still not over it, clearly, but I would have really liked some justice or some Judge Judy justice at least. I don't know. I'm holding a grudge and I shouldn't, but there's a good example. I'm sure we've all had examples like that in our lives where we wish that, the law could have been involved or given justice or whatnot. The 4 Ds of negligence. So negligence falls under tort law, and negligence is a pretty big issue with healthcare workers. 4 Ds of negligence include the practitioner owes a duty to the patient, and that duty was not met. The practitioner was derelict with that duty, so they performed the duty. They were acting dutifully, but they were not. They didn't do it correctly. They didn't do it morally or ethically. They did it wrong. And then the breach of duty was that the breach of duty was the direct cause of damages. And then the final one is damage or harm came to the patient. So usually one or more of these will fall under negligence. I think it's usually more than one. The patient is usually harmed. The practitioner is usually doing a crappy job about their duty. They had a duty and performed it inappropriately or whatnot. So there you have it, the 4 Ds of negligence. 3 types of damages in lawsuits. So we've gone through the law, and now these are usually what results as what comes as a result of people breaking that law. We have economic damages, we have non-economic damages, and punitive damages. Economic, awarded for economic loss. Non-economic damages, pain, suffering, disability, disfigurement, and loss of enjoyment of life. Or punitive damages, awarded to punish wrongful conduct and deter future unlawful conduct. So these are all things that can kind of be used as leeway in court to steer a judge or a jury one way or another towards the patient or towards the practitioner. Let's see. Continuing on, malpractice was kind of talked about. We have criminal malpractice, civil malpractice, and ethical malpractice. Criminal malpractice, assault and battery fall under that category, and this is resolved in a criminal court. Civil malpractice is where negligence was involved, and this is resolved in civil court. So a lot of the time, you have family members or patient that doesn't feel like they were treated well. I remember hearing a story one time that a paramedic had responded to. He was an off-duty paramedic. And luckily, there's a law now that protects you. It's called the Good Samaritan Law, something similar to that. Good Samaritan something law. Anyways, this off-duty paramedic responded to the scene of a person choking, and he was choking, they couldn't get an airway, blah, 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 blah. Long story short, this paramedic ended up saving this person's life by cutting a trachea, or a trach, basically cutting into his trachea, so that he could breathe. Saved his life, right? So a couple of years later, this patient takes the whole fire department to court. Even though this paramedic was an off-duty paramedic, he sues the fire department because he has a scar on his neck now. And it's not something that they could handle in criminal court. It's something that he took to the civil court, and he won. So the patient won. And it makes you sick. You try to do the best you can for patients, and then there's that one or two in the bunch of, huge amounts of people who ruin it for everybody. But because of that, those one or two people who choose to treat patients wrongly, or perform things they shouldn't be performing, or acting negligent to their patients, we have these laws and these malpractice places, court laws and whatnot, to help keep patients safe. And it's becoming more common to also be able to stand behind your caregivers and make sure that they are protected as well, because a lot of the time it was focused on keeping patients safe, and then at whatever expense to the healthcare provider, right? So that's becoming more appropriate and visible now, where the healthcare providers as well are being shown that they are protected, and that patients just can't treat them however they want. So how to avoid a lawsuit, right? Be aware and conform to all legal aspects of licensure and standards of care. Institutional risk management processes should be an ongoing component of health operation and professional development. Every therapist malpractice insurance. Active risk management practices and appropriate guest relation policies. Now, HIPAA. I'm sure everybody has heard of HIPAA. This is our confidentiality with our patients' medical records. HIPAA stands for the Health Insurance Portability and Accountability Act. It was enacted in 1996. It established standards for privacy of individually identifiable health information. Basic goal of HIPAA, this is pretty important, so remember this. Basic goal of ACT was to strike balance between protecting individuals' personal health information and not impeding exchange of information needed to provide quality health care. So not only are we protecting our patients' health information, but it also made it so that you only need the information you need to treat your patient. You don't need to have everything under the sun, every little bit of information. You don't have to have every little bit of somebody else's patient's information. You need to know what you need to know about your patient and what you need to know to treat them. That's basically what that's trying to get across. So, a little practice question. What is the basic goal of HIPAA? A, balance between protecting individuals' health information and providing quality health care. B, to reduce cost of healthcare. C, to ensure that all healthcare providers' accreditations are up to date. Or D, to ensure the patients never see their own medical chart information. That one's a pretty easy one. So A is the correct answer. The balance between protecting individuals' health information and providing quality healthcare. Medical supervision. RTs are required by scope of practice to work under competent medical supervision. RT's employer, either physician or hospital, is liable for the RT's actions. Professional licensure issues. Preventing problems. Respiratory Care Practice Act, the licensing statute. Understand causes of discipline, including substance abuse, domestic violence, sexual abuse, and gross incompetence. These are areas where you should be pretty familiar with if you're working as a respiratory therapist. You want to know what this Respiratory Care Practice Act covers for you. You want to know what that is so that you know how to work within those boundaries. And then you also want to know what you can and what you can't do, right? We've talked a lot about what you can do, but you also want to know what you can't do so you're not getting disciplined. Substance abuse. domestic violence, sexual abuse, and gross incompetence would all be cause for discipline as a respiratory care provider. Interaction of ethics and the law. Corporate compliance officer. This role oversees hospitals' business practices and make sure that those businesses and those hospitals are conforming to the law. They are available to discuss legal or ethical issues arising in the course of care. And the Patient Protection and Affordable Care Act, passed by Congress in 2010, improves whistleblower protections for hospital workers. Employer cannot discriminate against any employee. It's a pretty new law that we're working under now. National Labor Relations Act provides protection to hospital workers even if they do not belong to a union. Protects a worker when he or she engages in an act that would benefit all employees. Example, the respiratory therapist asks the supervisor to increase shift differential for all RTs who work that shift. And finally, the False Claims Act. This forbids making false claims against the government, provides severe sanctions against violators, including monetary, possible repayment up to 3 times the amount of false claim made against the government health plan, Medicaid, Medicare, and possible civil penalties. So we have these social systems, right, that are in place. But if they're being misused and abused, you can get in a lot of serious trouble. So both on the patient side and on the hospital side. So that's what this False Claims Act is about. It's a pretty big deal to make sure that you're using Medicaid and Medicare in an appropriate way. So that was really long and a lot of wordy information, but it is important to know, especially when we're working in a healthcare system that can be kind of overwhelming sometimes. You've got all this science and all of this clinical care that you're trying to learn, best practice for your patient, but you've also got, you've also got ethical and moral decisions that you're making, So it can be pretty overwhelming, but I think that a good rule of thumb is to treat people the way that you want to be treated, and to, if you have a question or if you're wondering, to not do anything until you ask. So, yeah, go ahead and go back there. I'll give you a couple areas of focus because I know there's a lot of information here. Make sure that you know about autonomy, about beneficence, about veracity, confidentiality, intuitionism, public law, tort, negligence, criminal malpractice, and HIPAA. So focus your study on those 10 areas and you should be good. Have a great week.